You're listening to 15 Minutes, where we feature community leaders sharing what the rest of us should know but likely don't.
Hello, listeners. I'm Bela Musitz, host for this episode of the 15 Minutes Share Your Voice podcast, where we talk with top-notch law firms and attorneys about what it takes to grow a successful law practice. This episode is brought to you by Gladiator Law Marketing. They deliver tailor-made services to help your firm establish its objectives and maximize your growth potential. To have a successful marketing campaign and to make sure you're getting the best return on investment, your firm needs to have a better website and better content. Gladiator Law Marketing uses artificial intelligence, machine learning, and decades of experience to outperform the competition. To learn more, go to gladiatorlawmarketing.com, where you can schedule a free marketing consultation. Today's podcast guest is attorney Jonathan Kocienda with the Connecticut Trial Firm, LLC. Jonathan is a litigation trial attorney with over 25 years of experience in medical malpractice. He has handled catastrophic injury cases involving paralysis, death, and other serious injuries. He has a proven track record of success in some of the most challenging medical cases. Welcome to the podcast, Jonathan.
Thank you. Thank you for having me.
Sure. So can you tell us a little bit more about the Connecticut Trial Firm?
Yeah, absolutely. So we're based out of Glastonbury, but we have a presence throughout all of Connecticut. I actually also practice in Massachusetts, primarily Western, but Massachusetts as well. And we are a personal injury law firm. We handle some of the biggest complicated medical malpractice as well as personal injury cases. We also handle and represent people who are injured in motor vehicle accidents, slip and fall accidents, as well as catastrophic construction and other types of accidents, where the injuries are devastating to their family, to themselves. Also the small stuff as well, the things that they can be very problematic, but it means something to them, but everyone gets equal representation. But the more complicated medical issues, that's where you need the right knowledge and skills, and our firm excels at that.
Excellent. Now, do you predominantly focus on folks who are injured, or do you also defend sort of the insurance company or the physician or, on the defense side?
So right now, and what we do is we're all plaintiffs. We represent the injured parties. My experience and my background are based on, I was first a plaintiff's attorney, representing the injured against hospitals and doctors and things like that. I did that for roughly 5-6 years. And then I actually went to the defense side and I represented hospitals, doctors, a lot of medical professionals. And I did that for almost 18 years. And then I'm now back. I switched back to the plaintiff's firm, and I'm representing again the catastrophically injured, the seriously injured patients that through negligence and through inappropriate, non-standard care, they get injured and they have to suffer through the rest of their life or possibly death. And so that's my background. But the firm represents plaintiffs, so we primarily bring the lawsuits against those who have done wrong and caused the injury.
Yeah, I can imagine that having experience on sort of both sides of the table is really important because you sort of understand how both sides work, and you can use that to your advantage, so to speak.
Absolutely. Well, there's multiple facets to why there's a benefit in medical malpractice, and particularly in Connecticut. The Connecticut medical malpractice bar, both the plaintiff's bar and the defense bar, are very small. This is a very specialized area. You really, you don't go to medical school, but you learn a lot about medicine and how the industry works and how medicine is delivered to patients. And so there's a benefit knowing all the defense counsel who I've worked with and known for years, right? And my reputation there is very good. It's stellar reputation. So dealing with them, they know who they're dealing with. I can deal with them. But also being on the plaintiff side, I know what it's like to be a patient. I have represented patients, so I also see it through their side, and I can cut to the chase and cut through the muck, so to speak, and really be able to see both points of view.
Right. Now, what percentage of these cases sort of go to trial versus are settled, outside?
Yeah. So I can speak mostly in Connecticut that I'd say roughly 90 to 95% of medical malpractice cases are settled before, often on the courthouse steps, but before an actual trial is underway. Sometimes you begin to panel and panel a jury, but 90 to 95% are settled beforehand. And, about five or maybe even less are actually tried to verdict.
Yeah. Now, do you also do the trials as well? Because I think
Yes.
that becomes even more specialized, I would imagine.
Yeah, so that's exactly right. So, some attorneys will make a distinction between a litigator and a trial attorney. And litigator is often loosely defined as someone who works up the cases, but never actually goes into the courtroom with a jury and tries a case. Without a doubt, we are trial attorneys here at Connecticut Trial Firm, which is hence our name. It's really
Yes.
There's such a push to settle cases. There's such a push by the judiciary and to settle cases that the art of trying a case, that skill is starting to slip away a little bit. And we pride ourselves on being able to do that. But my background and my experience is absolutely trying cases. And medical malpractice cases are some of the largest, 2, sometimes 3 weeks of evidence, a lot of witnesses, a lot of complicated terms. Putting that in front of a jury, presenting that as a trial, that's no mean feat. And so I do try cases. We also litigate the cases. We do everything nuts to bolts.
Yeah. So if you're litigating a case and once you come to an agreement, both sides come to an agreement, does that then need to be approved by the court?
Not in Connecticut, no. Connecticut does not require that there be a court approval of a settlement. The parties have to agree. Now, if there's a dispute after the terms are met and all of a sudden someone wants to change the terms or back out of agreement, then yes, the court would get in and maybe have to enforce that agreement. But that's very rare, and there's no court involvement. Once there's an agreement, they're very happy to get the case off their docket, move on.
Super. Does mediation come into play here?
Yeah. So having done this practice law for almost 30 years, but doing this for almost 20, 25 years, mediation's become very prominent. Or it used to just be pick up the phone and you talk to the other side, either the other attorney or the adjuster, or the claim rep, or the representative of the hospital itself. But now almost always cases in medical malpractice go to mediation. And that's just, I think, a general trend throughout all of litigation and trial work throughout the country. But medical malpractice has very much embraced that. So mediation is very much part of what we do. And that's itself its own art form.
Yeah. What's the difference between mediation and arbitration?
So mediation is essentially an informal discussion, often with a mediator. So the mediator is a third party who doesn't have a stake in the case and tries to get the parties to see enough of each other's case and a value of the case that they can agree to settle it. Okay. And you really don't debate the facts to the evidence too much in those mediations. And there's no evidence presented, and it's very informal. An arbitration is essentially a trial outside of the courtroom and often without a jury, where you have one or maybe 3 arbiters who sit in judgment as if they were the judge. Sometimes they are ex-judges. And they hear evidence, they hear witness testimony, and they actually make a judgment on the merits of the case based on that evidence, and they come out with a ruling, and the parties agreed by contract to abide by that and follow it.
Now, is arbitration ever used in these types of cases?
Very rarely. I think both sides, both defense and plaintiff, both agree that they'd rather have a jury of peers, the general population hearing the case. Although there are a few arbitrations where sometimes everyone kind of agrees this is not one that needs to go to a jury. And there's benefits to that. There's a lot of benefits. It's cheaper. In Connecticut, we're the only state in the union that has individual voir dire for jury selection. So in federal court and state court, you have a panel and you pick your jury within a day or two. In Connecticut, it could take up to a week, almost sometimes 2, 3. I've picked a jury in a month.
Wow.
Because you meet individually without any other jurors with the other counsel, and you talk to them and you go through, and then you can pick or choose. And they may be not on the jury because they're biased. There's a cause issue. That's a very slow process, and defense counsel are being paid hourly for that.
Wow.
Plaintiffs' counsel aren't getting paid at all for that. It doesn't add value to the case, although it does help with the jury. So there's a lot of benefits to arbitration. You avoid the jury selection, and and you can be cheaper. And then also you cut to the chase. Usually the arbitrator is aware of a lot of the nuances. You don't have to spend as much time in background. Witnesses can get testify sometimes in half or 75% of the time. And then you also have the benefit of scheduling intermittently. You can have a couple of days of arbitration, and then you might resume the arbitration a month from later when calendars and schedules allow for it. It could take a little longer that way, but the convenience of the attorneys as well as the witnesses, most of the witnesses are doctors and medical providers that are providing medical care, to take them out of that. And you don't want to harm the patients. You don't want to put patients out that are relying on those clinicians. So all told, sometimes arbitration is just convenient and cheaper for everybody involved. But most times it's not. It's a rarity.
Yeah. Yeah. Now, tell me, we've talked in sort of general terms, but this strikes me as a very competitive space, sort of in the legal profession. There's a lot of law firms. We all see the advertising on TV or podcast where people are promoting. What sets you guys apart?
So what sets us apart, medical malpractice is not you can't just pick up a medical malpractice case and know what to do. There's specific procedures and laws, and just the case law that's developed about medical malpractice and all the nuances are something that you can't just pick up because you've tried cases. You could be the best trial attorney for some cases, but medical malpractice, and then an integration of medicine and the science complication of medicine into how law works, and then presenting that to a jury. None of that is really something you can just pick up a book and read it and understand it. You need experience and practice. And that's what sets us apart, essentially, is me. I don't want to be big bragger, but what sets us apart with medical malpractice is that I have 25 years in the industry, both plaintiffs and defense, working 18 years with doctors and hospitals intricately, very, very intimately, knowing how things are done. And then just the years I've experienced in studying and learning about medicine, all that put together allows me to be able to present and understand and really be efficient, but really represent the clients very well. People who say they want to do medical malpractice, but don't practice malpractice, they're walking through a landmine. And they may not even know what they're missing at the end of the day.
Yeah. So as a firm, how do you guys find clients?
So a couple different ways. We certainly have, we have an internet presence. So there's, typical advertising like any firm, a lot of word of mouth and referrals. So there's a lot of attorneys out there who have clients for lots of reasons, anywhere from real estate, family law, other types of personal injury, that know that they couldn't and should not be handling malpractice cases. So they refer them to those who do. And that's where we get a lot of cases. But we get plenty of calls as well. I think by the end of the year, we'll probably get close to 1,000 or more.
Oh, wow.
The vast majority are not actual cases that we would take, but there's just a lot of people out there. And the more formalized and commercialized medicine becomes, I think the more people get a little frustrated and unhappy with medicine and the way it's delivered and their experiences. And so people just are asking a lot more than they used to.
Yeah. And how big is the firm? How many lawyers?
We have, we added a couple of attorneys, so it's hard to keep track. Quite frankly, I'd have to look to see what we're up to, but we're up to almost, I think, 10 now attorneys.
Got it.
Yeah.
Okay. That's a good sized firm.
Yeah. 8 to 10, I think, is where we are, somewhere around there.
Yeah. And so let me switch gears a little bit. What made you become an attorney? Let's go all the way back to, you decide I'm going to go to law school. What was sort of the thinking process and the motivation that took you there?
So, as I talk to my son, who's now in college, trying to figure out what he wants to do, I'm a unique person in the sense that my path was very different from most people because I knew what I wanted to do very young age. I actually knew I wanted to be a medical malpractice attorney at a very young age.
Wow.
My neighbor across the street who I grew up with, her father was an attorney. And so I learned a little bit about law and a little bit about what he was doing. And it was interesting. It wasn't something I necessarily wanted to do. My mother was an emergency room nurse for 30 something years and worked in case management before she retired. And so medicine always intrigued me. I also had uncles who were an orthopedic surgeon and different things. But one thing I learned early on was medicine, interesting as it was in short term, there's a lot of repetitiveness. You see the same types of things. I didn't want to do that. And somewhere along the way, around high school, I realized those two they can merge together. And I realized that would be perfect. Medical malpractice, I learned what it was like and what it was about. And so I kind of really knew I wanted to do that before I even got into college. So it was really a combination of my neighbor, who I respected a great deal, her father, and my mother and other family members that kind of just everything coalesced into wanting to do that. And so that's why I became a lawyer, but it wasn't just become a lawyer, it was become a malpractice lawyer.
Yeah. Yeah. So, you know, I had lots of sort of ideas of what I wanted to be when I was young. And I went down a particular path. And I can specifically recall there was a moment in time after I'd been working as an engineer for a number of years. I said, gosh, am I glad I made this decision to become an engineer? It's really working well for me. Did you have a moment like that?
Yeah, actually, yes, I've had multiple where it's been, reaffirming of my decision. I'll be honest with you, there's been a few where I've been like, what did I do this for? Why? Everyone has those moments as well. So to be fair, this wasn't like I never doubted myself. But yeah, there were definitely, and I'd say the first moment I had where that actually occurred was when I was representing a patient. Actually, it was years ago, and it was devastating. The family was just devastated. It was nothing they did wrong. It was no contribute. It was just bad. Even the defendants, they completely agreed malpractice occurred. The real issue was value of the case. There were a couple of holdouts, but when that was all over, and I realized we were able to change the life of that family for that poor injured individual. It was a child who can now have a lifelong care for what they went through. And I realized that if they didn't have that, how different their life would be. That's when I realized I'm doing the right thing.
Yeah.
It's maybe in a microcosmic way rather than the whole world, but the difference that made is just something it's selfish, but the feeling you get is just it's enormous. So that kind of really made me realize what I wanted to do.
Yeah, that must be super rewarding. Both emotionally, sort of personal satisfaction, et cetera. Yeah, that's great. Great. So if there's a young budding attorney out there listening to this podcast, what advice would you give them?
So the advice I would give, hands down, and I've given this many, many times to young associates, and is be curious. Want to learn not just legal procedure or rules of evidence, but want to learn the subject matter. The best advice I ever got was from a partner way back when I was brand new. I was taking a deposition of a doctor, as a matter of fact. It was a motor vehicle accident. And he, we're getting ready and he's trying to explain things. And he said, one of the best things you can do in a deposition is just ask all the questions that you're curious about. They don't always have to be related specifically to the case. It's an opportunity to educate yourself and answer your own questions that you might have and get explanations. And that can open up the world. And I've done that ever since. And so my recommendation is be curious. Want to just absorb everything and learn. You never know where some of that goes down the road for your case, another case, or just your life. And it makes life a lot more interesting if you're curious about what you're learning about rather than just going through the steps.
Yeah, that's great life advice and career advice all wrapped
exactly. It makes practicing law a hell of a lot better.
Yeah. So I want to start wrapping this up, Jonathan. So where can our listeners find out more about you and your law firm?
So you can find more about me. So you can start with our website, cttrialfirm.com. I'm on YouTube. I'm in LinkedIn. I've done a lot of presentations over the past 25 years. I have pretty good internet presence. If you Googled my name, I'll pop up in various locations. And certainly contacting me directly through my website, through the website or through my email is a perfect way to do it too. And my email is jak@cttrialfirm.com. Same as the website.
Great. We will make sure all that information is in the show notes. So Jonathan, my last question, is there something that I have not asked you that you'd like to share with our listeners?
No, there actually isn't. The only thing, I guess my final statement would be, the law can be extremely rewarding if you approach it with the right way. If it's not, and it's drudge work, and I've met plenty of attorneys who feel that way, don't do it. Find what you like and do that. But you'd be surprised if you're open-minded how rewarding law can be representing people who really need the help and cannot get themselves navigated through the legal system.
Yeah, great advice and a great way to wrap up this podcast. So, Jonathan, thank you so much for being a wonderful guest.
Thank you.
I really enjoyed our conversation.
Likewise, it was a pleasure meeting you, and thank you for having me.
Thanks for listening to 15 Minutes. Be sure to subscribe, and we'll see you next time.